Welcome to Dorsey and Whitney's webinar on the Supreme Court's term, highlights of 2019, preview of 2020. I'd like to introduce Steve Wells, a partner in Dorsey's trial and appellate groups. Steve?
Thanks. Welcome everybody to the virtual edition of our annual Supreme Court update. I'm Steve Wells, and with me is Tim Droske. We are the co-chairs of Dorsey's appellate practice. We are making our way through COVID land, this time from our respective homes. The deluxe broadcasting booth that you see behind me happens to be my dining table. I think Tim's in a spare room somewhere, but we're delighted to be with you today and talking about this really darn interesting year. I mean, if ever there were a year where the Chinese curse came true, maybe you live in interesting times, this is it. And there's so much to talk about. This is kind of a, I don't know, the cliche you want to use, curated, bespoke selection of cases that we're going to be talking about today and some statistics that we think are really important. Before we launch into this, let me just do go over a couple of housekeeping items. So the first is this is going to be 60 minutes and we're going to hold it pretty closely to 60 minutes. What that probably means is that there won't be a lot of time for Q&A and probably none. But if you'd like to ask us some questions, please use the chat function. If we have time, we'll address them. Likely we won't, but as long as we have your email address, we promise to get back to you in response to your questions. So I think that's actually a kind of an advantage of the virtual format. Third, if you want to get CLE credit for this, then by all means return the sign-in that came with the email update that you got yesterday reminding you of this seminar. And we'll have an announcement, I think, a little bit into the presentation for those of you in New York who need the New York CLE number. With that, let me turn to the topic of our presentation today, the Supreme Court term, the 2019 term and the upcoming 2020 term. First, let me say a few words about Justice Ruth Bader Ginsburg. And I think we all know the basic facts about Justice Ginsburg's tremendous career on the court. Of course, she died from complications of pancreatic cancer on September 18, 2020. She was nominated to the court in 1993 by President Clinton, and she served 27 years on the court. She was just the second female justice appointed to the court. On Saturday, September 26th, of course, President Trump announced that he would nominate Judge Amy Coney Barrett to fill the late Justice Ruth Bader Ginsburg's seat, and the Senate has promised a quick vote on her confirmation. Before there's been so much said about Justice Ginsburg. I only add a couple of things that were really kind of personal to me in my practice about Justice Ginsburg. For really the last 20 years, the focus of most of my pro bono work has been in the capital punishment and death penalty area. I teach a class on it at the university, represented many defendants on death row. Justice Ginsburg's not noted for her for having the kind of impact in the death penalty world that she had in matters relating to equal rights and those things, but she did have a very significant impact, even in the world of capital punishment. For many years, there was a debate among the Supreme Court justices, essentially, as to whether somebody who is actually innocent, who could prove that they were actually innocent, could actually raise actual innocence as a defense if they were otherwise barred by a number of the procedural obstacles that are put in place by the Anti-Terrorist and Effective Death Penalty Act. And so the question was, if you had struck out getting all of the due process that you were entitled to, but for whatever reason could still mount an actual innocence defense, would you be allowed to do that? Famously, Justice Scalia said no, that lines had to be drawn, and once you got your due process, that was it, and by definition, you weren't innocent. In a case called McQuiggan versus Perkins in 2012 or 13, Justice Ginsburg really put that to rest. And she said, essentially, of course. In that case, the defendant had a lawyer who failed to comply with the requisite statute of limitations, but who had evidence that he was actually innocent. And Justice Ginsburg fashioned an opinion that both went through the history of the death penalty and talked about what was called the miscarriage of justice exception, wove it into the statutory framework, and came out with an opinion that I think was ethically, morally, and judicially correct and well-reasoned. And I will remember her particularly for that decision. The nominee for her replacement is Judge Amy Coney Barrett, and Tim's going to talk a little bit about her.
Thanks, Steve. And I too was sad to see Justice Ginsburg pass. As someone who's the father of 6 daughters, I think what she did to just break the glass ceiling was truly remarkable, and her long legacy on the court and as an advocate for equal protection under the law for women is truly remarkable. In terms of Judge Amy Barrett, she is currently sitting on the 7th Circuit Court of Appeals. She was appointed there 3 years ago by President Trump after having a long and distinguished career, primarily in academia, teaching at Notre Dame Law School, where she had also graduated top in her class. She clerked for Justice Scalia, who she credits not only as her mentor, but also as the jurist who she herself wants to model herself after. And again, she was nominated this past weekend. And the question now is largely for the court, how long will it be operating as an 8-member court as opposed to a 9-member court? You know, if you read the press and follow things, her confirmation seems likely here, as long as the Senate Republicans remain unified. The Senate Democrats can perhaps slow down her confirmation, but it will be difficult for them to stop it. But the timing for when she's confirmed matters here a lot. While the court will continue to do business as usual, as best it can, it will look different. One way that that'll be visible will be with respect to the cases that are granted for review. It still takes 4 people right now for a certiorari to be granted, the same as it did when it's a 9-member court. And historically, the Supreme Court is reluctant to grant certiorari when there are only 8 members on the court, partially because a 4-4 decision is so unsatisfactory. All that will happen in those circumstances is a 1-line order saying that the judgment of the decision below is affirmed by reason of an equally divided court, which is, again, pretty unfulfilling to the litigants, to the court, really to the American public. And so there's a disincentive to grant review. And in terms of cases that are being decided, it's not until a justice is confirmed and then sworn in that they can start sitting on the court and deciding cases that are heard for oral argument. As a result, what that means is that with oral argument starting this term, starting next week, the court is going to be issuing at least some decisions from an 8-member court. And as we look ahead to some of the key decisions coming down the pike, the Affordable Care Act decision that's before the court, for example, is getting a lot of attention. That's going to be heard in early November. The question of when it will be a 9-member court matters a lot. Steve?
Well, the court had to respond to COVID just like all the rest of us did. And it did follow a little bit of a precedent in the sense of dealing with the Spanish flu outbreak in 1918. Some of the aspects were the same. It suspended oral argument. It extended the timeline from 90 to 150 days to file a certiorari petition, an extension which is still in effect, actually. And it completed the full term despite COVID-19. Cases were down, but it did complete the term. One innovation was oral arguments via telephone, with each justice being given the opportunity to speak, and a kind of, I would say, a more orderly progression to questioning and to answers than often happens in oral arguments. If you've ever seen any oral arguments or listen to them, you know that sometimes the justices are talking over each other. Sometimes they're trying to make points to each other and don't even allow answers to the questions that they ask. And there was, I think one benefit of telephone arguments essentially is that it had a more of a linear progression to it. It also allowed for there to be background noises, including the quote, flush heard round the world, in which somebody, no one knows exactly who at this point, used the facilities apparently when the microphone was live. I think the question is whether some of these innovations will continue. Certainly they're going to continue in the short term, but will there be live streaming going forward, live streaming of arguments? There'll be video arguments to come? Will we have Zoom arguments that are available to the general public at the time that they're made? All questions I think that remain unanswered, but I think given sort of the world that we live in right now and public acceptance of this kind of technology, it's reasonable to think that the court might actually adopt some of them. Dan.
So now we'll start looking through some of the statistics from last term. And these are largely compiled through SCOTUS blog. So anyone who's interested in diving at the numbers more deeply, that's a great resource for some of these statistics. The first one we'll look at is the number of cases decided. On average, over the past decade, there have been 74 cases decided a term. And this last term saw a big drop off, down to 53 cases that were decided by way of signed opinion. So that doesn't count per curiam opinions or summary reversals. That can largely be attributed to COVID. The court did its best to readjust and get through the term, and they had to extend the term into July as opposed to their usual end of June cutoff. But it did affect how the spring term looked. And going into this upcoming term, where similarly arguments are going to begin telephonically, and now with an 8-member court, my suspicion is that there would be a lower number of cases decided in this upcoming term as well, compared to the historical average. In terms of the outcomes of the cases, again, it's the 5-4 decisions that are the cases that you usually hear about, but the most common voting number, I'm actually on the wrong slide. I'll get to that next. In terms of outcome, first of all, usually the rule of thumb is that the Supreme Court grants review to reverse it, and that was certainly the case this term. 68% of the cases were reversed compared to 32% which were affirmed. That was a 4% higher reversal rate than has been seen in other years. In terms of which circuits, did the best, the Sixth Circuit had all 3 of its cases affirmed. The Eighth Circuit only had 1 case before the Supreme Court, but it was affirmed. The Third and Seventh Circuits, on the other hand, had 100% of their cases reversed, but they also only had 1 case before the court. And the perennial punching bag, the Ninth Circuit, was true to form this past year. There were 10 cases reviewed from the Ninth Circuit this past year, and 9 of them were reversed. And now getting to the vote splits. 9-0, a unanimous opinion was the most common voting split that you saw this past term. So in more than a third of the cases, the court issued a unanimous opinion, and that was more common than any other vote split. The second most common was a 5-4 decision. That happened 23% of the time. And as we start moving into some of the specific cases that came out last term, a number of those 5-4 splits are going to be the ones that we are focusing on. Steve?
So the conservative bloc on the court continues its hold. There were a total of 14 5-4 decisions, and the most common majority in those 5-4 cases was the conservative bloc consisting of Justice Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. That's actually the same as the last term, and this happened in about 10 cases. There were only 3 cases with a 5-4 majority where the liberal bloc and a conservative swing vote prevailed. Roberts was the swing vote in 2 of these decisions, and Gorsuch, somewhat to most people's surprise, was the swing vote in 1 of them. And the remaining 5-4 decision consisted of Justice Roberts, Sotomayor, Kagan, Gorsuch, and Kavanaugh. In total, one thing that was really different this year, in total, there were only 4 different combinations of justices for the majority in the court's 5-4 decisions. That's unusual. This is a significant drop from last year when there was a lot of kind of mixing and matching going on in the 5-4 decisions. In fact, last year there were 10 different combinations compared to this year's 4. And it's even below the average, which is 6. One other interesting thing I thought is this year, and this, I haven't gone back to previous years, but I think this follows a trend, is Justices Alito and Thomas sided with the administration, not necessarily the rationale, but with the outcome that, that the Solicitor General advocated in every single case. I'm not sure exactly what that says, but I think it's an interesting phenomenon and one that we can't ignore. Let me just talk about who's most likely to be a swing vote in these 5-4 cases. As I said, Justice Roberts joined the liberal bloc two times in 5-4 cases. Justice Gorsuch joined the liberal bloc 1 time in 5-4 cases. And so, Tim, I'm going to hand it over for you as to who is going to be most likely to be in the majority.
Sure. Well, thanks, Steve. It truly is Justice Roberts's court right now. It's no longer the Kennedy court, no longer the O'Connor court. The Chief Justice is the vote that matters. He's in the majority 97% of the time, showing likewise that he's center right as opposed to far to the right. Justice Kavanaugh is most likely to be in the majority 93% of the time. I do think it's interesting when you look at who's most likely to be in the majority. Justice Gorsuch and Justice Thomas, when Justice Gorsuch first came on the court, were in perfect voting alliance. And as you can see, Justice Thomas has continued to be a voice of dissent, while Justice Gorsuch is more likely to be in the majority. In terms of agreement on case outcome, it's the 2 Clinton appointees who were tied, who were at 90% and most likely to agree on case outcome, Justice Ginsburg and Justice Breyer. And then you had the 2 Republican appointed DC Circuit judges, Chief Justice Roberts and Judge Kavanaugh, who were also tied with 93% agreement. Like Steve said, Justice Thomas and Justice Alito have been in lockstep much more frequently, and that's reflected in terms of the statistic here on the screen. In terms of least likely to be in agreement, you can see at the bottom here that Justice Thomas and Justice Sotomayor only agreed on case outcome in 44% of the decisions. In terms of the most majority opinions authored in 5-4 cases, it's Chief Justice Roberts and Justice Kavanaugh who each issued 4. I think that's notable for Chief Justice Roberts because as the senior member on the court, he gets to choose who is going to author the opinion. And so he's intentionally taking the pen up himself in these close 5-4 decisions, where based on his overall judicial philosophy, he is commonly favored in public about saying that he would prefer narrower opinions that could be unanimous, but he's not taking the pen in those unanimous opinions. It's the 5-4 decisions this past term. In contrast, the most unanimous opinions were issued this past year by Justice Ginsburg, Justice Kagan, and Justice Gorsuch. And they each issued 4. Justice Roberts, in comparison, did not write any. In terms of who is writing the most dissents or fewest dissents, Justice Thomas led the way with 12. And that's twice as many dissents this year compared to last term. You can see that Justice Sotomayor, for the more liberal side of the court, has written the most dissents at 8. And it's not too surprising to see Chief Justice Roberts and Justice Kagan with the fewest number of dissents at 1. Both of them are often viewed as kind of the 2 most institutionalist-minded members of the court, and who are careful in protecting the court's outward-facing image. And as a result, it's not surprising that they would perhaps be the least likely to write their own separate dissent. Oral argument, always interesting, and it was Justice Sotomayor again who won the crown for the most active questioner at oral argument. She would on average ask 21.2 questions per argument, and was also very often the first questioner off the blocks. Now, these are statistics that, again, pertain to kind of the first half of the term before COVID changed the way that the court was doing arguments telephonically. In terms of Justice Ginsburg, she was the second only to Thomas in the fewest number of questions asked at oral argument, but she was often one of the first ones off the block. You had a 60% chance of Justice Sotomayor or Justice Ginsburg asking the first question. When argument was proceeding normally, Justice Thomas again asked no questions last term, as is his common practice. But once the court changed its format telephonically to giving each justice a certain designated period of time, Justice Thomas did in fact use that time allotted to him and did ask questions. Steve, I'll turn it over to you for any takeaways.
Well, I think it's clear that given the number of 5-4 decisions and the voting on the 5-4 decisions, that the conservatives still control the court. But it's not. But they aren't acting in lockstep, and voting alignments have been less predictable than you might think. To call it a liberal bloc or a conservative bloc is probably a little pejorative and inaccurate. Because on some issues, criminal law, Indian law and rights, we see, and stare decisis are three big issues in which you see kind of an unusual lineup of justices that might not be adhering to what, from a maybe a superficial standpoint, we would think would be their predilection. So I think conservatives control the court. There is still some maybe unpredictable, maybe unexpected mixing and matching going on in the court. It's not a monolith on either the left or the right. And Justice Gorsuch is emerging as a swing vote, at least in some areas of the law. The two justices who are clearly the institutionalists are Chief Justice Roberts and Justice Kagan. They draft the fewest dissents, and they often craft majorities that cross ideological lines in divisive cases. It's an interesting term when two completely separate cases decided at separate times go into great detail about the relationship between President Jefferson and Aaron Burr in 1800 through 1807. The court spent a lot of time in that era, and I thought it was just fascinating. The first cases I'm going to talk about are the cases in which President Trump was subpoenaed for personal records. And these are very important cases, I think, in some cases breaking new ground, in some cases rejecting some new arguments. So the first case that I want to talk about is Trump versus Vance. This was a case that involved a state court criminal subpoena. Vance is the New York official, the New York County District Attorney's Office that opened an investigation on President Trump's finances. And they subpoenaed his personal accounting firm, Mazars USA LLP, and they subpoenaed them for records. They had kind of a vague explanation about why they wanted him. They noted that business transactions may have violated state law. So that was the basis for the subpoena, and that went to the court. Trump and his personal lawyers actually sued the state to stop it and sought to intervene to stop the subpoena ducis tecum from going forward. The district court denied that. The Second Circuit denied that request. And then it went to the Supreme Court. And in the Supreme Court, President Trump essentially had two arguments. He argued that he had absolute immunity from state criminal process, including any state criminal subpoenas. And he argued that that was so because the state criminal process could be a distraction, it could be a vehicle for harassment, and it would interfere with the discharge of his constitutional duties. He argued in the alternative that if there was no absolute immunity, at least there should be a heightened standard for getting personal records from his accountant. Important here is there was no claim that any of the records here involved executive privilege. These were personal financial records for President Trump and his family. Well, the court shot down the first argument in an opinion by Chief Justice Roberts I have to say, I really think it's one of his better opinions. It's well reasoned. It does talk a lot. It goes back to the history of criminal subpoenas directed to presidents. And the first one happened to involve President Jefferson, who was subpoenaed for his records involving his communications with Aaron Burr, who was charged with treason for, and I had forgotten this, for attempting to raise an army to attack Mexico in 1807. And in that situation, even though by that point Jefferson and Burr were bitter enemies, Jefferson at first resisted it, and John Marshall, in an opinion in 1807, held that there was no basis for the president to withhold records, that every man was entitled to his evidence, is how the Chief Justice put it, and therefore he couldn't resist a subpoena. Now, this was a federal court subpoena, and Trump argued that there should be a different rule for state court subpoenas, but the Chief Justice was having none of it, and held that that based on the record of the federal court subpoenas, and there was no reason really to distinguish between federal and state court criminal subpoenas when it came to this issue. And so the court held in a very, as I said, a very well-reasoned decision by Chief Justice Roberts that there was no absolute immunity for state criminal process and state criminal subpoenas by a president. The Chief Justice also held, the majority held, that there was no reason for a heightened standard in this case, that it simply wasn't appropriate because there was no involvement of executive privilege. And that kind of the standard executive privilege does not extend to papers of a personal nature. There were dissents. Justice Thomas dissented, and Justice Alito did too. Justice Thomas's, I would have just sent it back to the court, the lower courts, for basically sort of more proceedings about balancing the relationships and balancing the real needs. Justice Alito, though, argued, he acknowledged that there should not be absolute immunity, but vehemently disagreed that such subpoenas should not be subjected to a heightened standard, as the majority had held, and argued that there should be a heightened standard whenever a president is subpoenaed. In the second case involving a subpoena that was directed to President Trump, and again his personal papers, there's actually two cases: Trump versus Mazars USA and Trump versus Deutsche Bank AG. So this was not a case of a state criminal subpoena, but instead congressional subpoenas to the president for information. And Justice Roberts wrote the opinion for the majority here, but took a very different tack when it came to congressional subpoenas because of its implication of separation of powers. It was also treading, unlike a criminal subpoena issued by either the state or federal courts, this was the very first time that the court had dealt with congressional subpoenas to a president. Although Congress has sought numerous documents from numerous presidents and there were disputes, they were always worked out between those branches of government. Here, there was a clash and neither side was giving ground. So again, the court goes through a very careful historical analysis of the power of Congress to subpoena and under what circumstances it can and can't issue subpoenas. And ultimately comes down on the side of that Congress has a right to issue a subpoena to a president, but the lower courts here, according to the majority, had not taken into account the important separation of powers issues and had not been careful in how they had decided the case to make sure that Congress wasn't overstepping its grounds and that this wasn't being used as a tool for harassment, and that there was a legitimate and important need in this case for these two independent branches of government to be seeking information. Again, this is there was a dissent by Justice Thomas, and he stated flatly that Congress did not have the power to issue legislative subpoenas for private, non-confidential documents, and that if Congress wanted such documents, it had to proceed under the impeachment power. Tim?
Thank you, Steve. Sorry, I hope people can hear me now. So the case that I'm going to talk about relates to administrative law, but also ties into executive authority and political issues regarding immigration. And that's the case of Trump v. NAACP, which was consolidated with the other cases that you see on the screen. This was a closely followed and very politically charged fight over the DACA program, the Deferred Action for Childhood Arrivals program that was established by the Obama administration in 2012 by the Department of Homeland Security, and that the Trump administration then sought to terminate. And the parties in this case did not dispute that the new administration could terminate the program, but the question was whether that termination was reviewable under the APA, the Administrative Procedures Act, and whether the manner in which it was terminated here was arbitrary and capricious. So quickly, just a little bit of background. DACA has two features. It allows certain unauthorized aliens who enter the United States as a child to apply for a 2-year forbearance of removal, and also allows those individuals to be eligible for work and receive various benefits. So you have forbearance of removal and then also the federal benefits. A couple of years later, after the program was initially created, Department of Homeland Security announced that it would expand the program and also create a similar program called DAPA, Deferred Action for Parents. So while the Obama administration is in power, DAPA and DACA's expansion gets challenged in the courts. And the Fifth Circuit affirms a preliminary injunction saying that the benefits prong here is manifestly contrary to the Immigration and Nationality Act's careful designations of who could qualify to receive benefits. And that Fifth Circuit opinion then became the basis for the Trump administration terminating the DACA program. So following the changes in presidential administrations, DHS rescinded its proposed DAPA program and then issued a memorandum concluding that DACA should be terminated and set out a process for winding down the program and saying its reason was the Fifth Circuit's ruling. In a 5-4 decision with Chief Justice Roberts writing for the majority and joined by the more traditionally liberal members of the court, the court held that the department had failed to provide sufficient reasoning for its termination of DACA. It first held that this was reviewable under the APA, rejecting the government's argument that DACA was really just a question of discretionary enforcement and not reviewable. And then having found that it could review the decision, found it arbitrary and capricious. And the reasoning was that the Fifth Circuit solely said that the benefits prong of DACA was contrary to law. It didn't say anything about the forbearance aspect, and that if the department was solely pointing to the Fifth Circuit's opinion, it was arbitrary and capricious to terminate the entire DACA program, including the forbearance part that people had developed a reliance interest upon without providing further reasoning. I think the important takeaway with the case is that it highlights that even in an area, again, where it's acknowledged that the executive administration could terminate a program, go in a radically different direction than the prior administration, the court is still there to engage in judicial review and make sure that the APA's procedures are being followed. Steve?
The next case we're going to talk about is Hernandez versus Mesa. So this was a case that was in the news and certainly politically important over the last 2 or 3 years or so. At the border in Texas, a 15-year-old was shot and killed by a U.S. Border Patrol agent. The Border Patrol agent was on the U.S. side. The youth was on the other side. There was a wide disagreement about the circumstances of that shooting, but those are the basic facts. The family of the boy who was shot brought suit in the U.S. Under a Bivens theory. Now, you may remember that Bivens versus 6 unknown federal narcotic agents is a 1971 case in which the court implied a cause of action for damages for violation of the Fourth and Fifth Amendment, later the Eighth Amendment too. So this isn't under a tort statute or anything. It's a judicially implied cause of action for damages against what really was sort of designed to be rogue federal agents. The question in this case was, would Bivens be extended in these circumstances where the person, the family who was the plaintiff had the crime essentially occurred on foreign property, although it was allegedly perpetrated on the U.S. side. And so the issue was, would Bivens be extended? And Justice Alito wrote the opinion and made kind of short work of this. Basically said, look, we don't like Bivens. We've been cutting back on Bivens and not extending it for the last 2 decades. There's all sorts of problems with Bivens. We're not going to overrule it, but we're not going to extend it in these circumstances too, because international relations are involved. There's issues about whether or not this would disrupt the kind of military discipline around the Border Patrol, the Border Patrol's conduct, and we just think it's basically fraud, and we're not going to go there for Bivens. And I think I think it's not a shock to those of us who were watching this, given that Bivens has been kind of disfavored, the extension of it anyway, in recent jurisprudence. But Justice Ginsburg, I have to say, dissented. She basically said, look, there's nothing new here. If this had all happened on the US side of the border, we wouldn't have an issue. We have an allegation, not proven, but an allegation of a rogue agent who, if you believed the plaintiff anyway, essentially in cold blood or overreaction, shot a youth without justification. The only thing that's new about this is that the plaintiff was on the other side of the border, and so she said it really doesn't differ from Bivens. It's not new. She analogized the case to a number of different Bivens cases that had been affirmed over the years, and she said at the end, it's all too apparent that to address injuries like the one suffered here, it is Bivens or nothing. And I resist the conclusion that nothing is the answer required in this case. Tim?
Russo v. June Medical Services was an abortion case before the court last term that got a lot of attention. And it's not because this was a new kind of abortion-related restriction passed by a state law that hadn't been before the court before. Instead, what was noteworthy about it is that it was so strikingly similar to the very same kind of law that had been before the court just 4 years earlier, with now the difference being a different court composition. So 4 years ago in Whole Woman's Health v. Hellerstedt, the Supreme Court struck down as unconstitutional on a 5-4 vote a Texas abortion law that required abortion providers to hold active admitting privileges at a hospital within 30 miles of the place where they perform abortions. And that was a law that resulted in the number of facilities providing abortions in that state to drop in half. Now, notably, Chief Justice Roberts dissented in the Whole Woman's Health case and would have upheld the Texas law. Fast forward to this term, Louisiana has enacted a law that was nearly word for word identical to the Texas law. The district court engaged in fact finding and engaged in a weighing of the different interests in the case, and found the law to be unconstitutional. The Fifth Circuit reversed that, finding that the factual findings were clearly erroneous. It went up to the Supreme Court, and the question was, how is the court going to treat stare decisis when you have a case that's so clearly on all fours? At the same time, when you had Chief Justice Roberts, for example, who dissented last time, and you have a more conservative-leaning court now. The Louisiana law was found to also be unconstitutional following the precedent from Whole Woman's Health. This was largely unsurprising, but it was a plurality decision with Chief Justice Roberts issuing a vote of 1 that ultimately was the vote to follow Whole Woman's Health. Chief Justice Roberts expressly acknowledged that he dissented in Whole Woman's Health and said that he continued to believe the case was wrongly decided, but on stare decisis grounds, with this case being so clearly the same, needed to find this law invalid as well. Interestingly, he did specifically note that the parties agreed that Planned Parenthood v. Casey was the governing framework, and that no party had asked the court there to reevaluate or reassess the Planned Parenthood v. Casey framework, perhaps leaving the door open to that being taken up by the court in the future. And Chief Justice Roberts also went back to Planned Parenthood v. Casey and laid out his view of what that precedent is. And most notably, it was his view that the court should not be engaging in a review of the legislative findings upon which an abortion-related statute rests and weigh the law's asserted benefits against the burdens it imposes. Instead, he said that's the legislature's job. And so long as the state has legitimate purposes and the law can be reasonably related to that goal, the only question for a court is whether a law has, quote, the effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. And so it raises the question going forward of stare decisis' role, as well as whether courts will impose upon state laws the same level of scrutiny that occurred in these cases. Steve?
The next case is Trump versus Pennsylvania. This is one of Justice Ginsburg's last dissents, and it's really another chapter in the ongoing saga over the contraception mandate. The final rules promulgating the Affordable Care Act were enacted under President Obama, required employees to provide contraceptives to their employees. Now, these are rules. So the rule was known as the contraceptive mandate. When President Trump took office, the Department of Health and Human Services, Labor and Treasury all enacted rules exempting certain employers who had religious or conscientious objections to the agency-created mandate. And so the question was, can they do that? Was the rulemaking correct, and do they have the authority to do that? Essentially undoing the rules that were promulgated during the Obama administration. In a 7-2 decision authored by Justice Thomas, the court said the Trump administration departments did have the authority to undo rules that were promulgated under the Obama administration, that the exemptions that were created for persons with conscientious objections didn't contravene the intent of the statute, which was vague when it came to, at least according to the majority, vague when it came to exactly what preventive services would be available to women. And so essentially they said, since it doesn't contravene the express language of the statute, and since it's just a rule, rules can be promulgated and rules can be unpromulgated, and there was nothing wrong with what happened here. Again, in a 7-2 opinion. Two interesting things I think about this. One is a concurrence by Alito, who was joined by Justice Gorsuch, who gave a view of the Religious Freedom Restoration Act that we're starting to see sort of more and more when it comes to statutory issues that involve allegations of religious freedom. And they agreed with the reasoning of the majority, but they would have gone a step further to say that RFRA, our RFRA, does not, that the court erred by saying that the Court of Appeals erred by holding that RFRA did not compel the exemptions promulgated. They thought, Alito and Gorsuch, thought that RFRA required these exemptions and that the lower courts had erred. No one else joined them in that, but that is an argument that is becoming more and more prominent in Supreme Court decisions that involve allegations of religious freedom, that there's kind of an independent basis requiring exemptions for any issue that a corporation or a private individual holds based on a conscientious belief or a religious belief, and that has to be taken into account in statutory schemes. Justice Ginsburg really focused on how this gave essentially carte blanche to agencies to secure exemptions for persons with religious rights that really had a practical and terrible effect on people. And her dissent focused on how many women would lose access to contraceptives and be forced to purchase contraceptives out of their own pockets. And that she thought that was a misuse of the free exercise clause and also contravened the important purpose of the statute itself. Tim?
Well, thanks. So a landmark case that was decided last term was RG and GR Harris Funeral Homes, consolidated with Bostock and Altitude Express. And this raised the question of whether Title VII's protections against discrimination apply to gay and transgender people. And this really became a textualist showdown. Justice Kagan once said in a tribute to Justice Scalia that we are all textualists now. And that really kind of came out in this opinion. The language of Title VII itself is what was the focus here. Title VII of the Civil Rights Act of 1964 commands that it is unlawful for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. And the question here was, what does the term sex mean? Now, it was admitted across the board that the legislatures in 1964 didn't envision the term sex as extending to LGBT protection. But the question was, looking at the language itself, what does it compel? And Justice Gorsuch, joined by Chief Justice Roberts, as well as Justices Ginsburg, Breyer, Sotomayor, and Kagan, found that Title VII protects gay and transgendered people. The holding from the court was that an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. Now, in the dissent, Justice Alito, joined by Justice Thomas, argued that the majority's decision was, quote, humane and generous, but was legislation, just cloaked in textualist clothing. In Justice Kavanaugh's dissent, he again looked at it from a textualist perspective, but said that courts should apply the ordinary meaning to a statute, not just its literal meaning, which is what the majority did here, and that instead it was for Congress to provide the protection that the court here in its majority extended. Again, it's interesting to see Justice Gorsuch writing this opinion. Some commentators have flagged whether the same analysis, what it could mean going forward. If you apply it to the term race, for example, in Title VII, could it be found that affirmative action is not allowed under a similar textual approach taken to the majority here? Those are obviously all questions for future cases, but this was a significant case here, particularly since fewer than half of the 50 states have similar protections to LGBT people. Title VII's extension here was significant. Steve?
Next case is Our Lady of Guadalupe School versus Morrissey Barrow. This case involved the ministerial exception essentially to employment laws, which is a judge-made, judge-created exception to employment laws that are applicable to religious institutions pursuant to the First Amendment. The question in this case was whether two plaintiffs, one who sued the school, she was a teacher at a religious school, sued the school because she alleged she was fired because she sought treatment for breast cancer, and another in another school who alleged that he was a victim of age discrimination, whether they would be subject to the ministerial exception to employment laws and not be able to bring their discrimination cases. And the court held that even though these were not ministers in these schools, they did teach some religious education, but they did not have the title or function of a minister, that because essentially they were involved in some religious duties, that teachers as well as ministers can be subject to the ministerial exception and will not be allowed to bring employment claims. There were a number of concurring opinions and a dissent by Justice Sotomayor and joined by Justice Ginsburg, again, in a very kind of stinging dissent about the impact of this on the employment laws for people who work at religious schools, aren't ministers, and whose firing by any account, so not the schools and not the teachers, had anything to do with religious reasons. Tim?
So in a case related to ERISA litigation and also touching on class action and Article 3 standing is the case Thole v. U.S. Bank N.A. And this is a case for a Dorsey client. Dorsey and Whitney, led by Steve Lucky and Andrew Holly, our partners in the ERISA litigation group, prevailed for U.S. Bank before the district court, the 8th Circuit, and then were co-counsel with at the U.S. Supreme Court, where U.S. Bank won again in a 5-4 decision in this case. The case really posed standing related issues. The facts here were that the plaintiffs and petitioners were retired participants in U.S. Bank's defined benefit plan, and they brought a putative class action under ERISA for alleged mismanagement of the plan during the economic recession from 2007 to 2010. The issue, though, is that the plaintiffs continued to receive the same pension payment each month, regardless of the plan's value or investment decisions, and are legally and contractually entitled to receive those same monthly payments for the rest of their lives. And certainly when the litigation was going on here, that there were no issues concerning the funds and the solvency of the plan. So on that basis, the district court in Minnesota dismissed the case under Article 3 grounds, standing, mootness, and the 8th Circuit affirmed, but instead relied on a decision kind of unique to its court on statutory standing grounds. And statutory standing has been largely kind of repudiated from the Supreme Court, and so it wasn't too surprising that it caught the Supreme Court's attention. What these kind of cases relate to, pose similar questions to what has come up in the Spokio decision, and that's a line of class action related cases that deal with the case of when you have a statutory right that's given to a private citizen, and then also a private cause of action. Is that in and of itself enough for that person to bring suit, or do they still need to show some sort of injury in fact for Article 3 purposes in order to bring that lawsuit? That was kind of that was posed here as well, and here in the 5-4 vote, Kavanaugh wrote a short 8-page analysis saying that the analysis here is actually relatively simple and straightforward. There's no ERISA exception to Article 3. An injury in fact is required, and here the plaintiffs lacked Article 3 standing for a simple common sense reason. They have received all their vested pension benefits so far, and they are legally entitled to receive the same monthly benefits for the rest of their lives. So this kind of Article 3 analysis, certainly significant here in the ERISA landscape, but could also have applicability to data breach actions or telephone Consumer Protection Act claims with robocalls and things of that nature. So a significant case in that respect for class action litigation and standing that's required. Steve?
Briefly, let me talk a little bit about Ramos versus Louisiana. 2 issues in this case. It involved the laws in 2 states, Louisiana and Oregon, which allowed a felony conviction based on non-unanimous juries. Those are the only 2 states that had such a law. And the question was, does that violate the 6th Amendment? And second, if it does, what do we do about it? Because there is this case, Apodaca, that looked at exactly the same question several years ago and determined that it was not in violation of the 6th Amendment. So in a decision issued authored by Justice Gorsuch, 6-3 opinion, joined by Ginsburg, Breyer, Sotomayor, and Kavanaugh, the court held that it did violate the 6th Amendment, that in fact, these sort of exceptions to the unanimous jury rule grew out of sort of Jim Crow laws and the rise of the KKK, and were specifically kind of racist in origin. And the court held that they did violate the 6th Amendment. So then the question is, well, what do we do about it? And why are we even taking this case? Maybe because of the Apodaca case. So it provided I think, a little insight into stare decisis and how the court is going to look at stare decisis. The court looked at Apodaca. It found that there was a 4-4 split on whether there was a violation of the Sixth Amendment on the straight issue that was presented. And then one justice, Justice Powell, who held that although he thought that under federal law, it violated the Sixth Amendment, using the 14th Amendment and applied to the states had a different standard, and therefore it didn't violate the Sixth Amendment when it came to the applicability to the states. What the court said was, this court said was, well, he openly acknowledged that he wasn't allowed to do that. He openly acknowledged that he wasn't following precedent because there is no separate standard for the Sixth Amendment's application to the states versus the federal government. So we think in this situation, we can get around stare decisis. We don't think it violates the theory of stare decisis. And so we're going to invalidate these laws, and that's what they did. Yeah.
So this next case, Barr v. American Association of Political Consultants, was a case involving the Telephone Consumer Protection Act. But what's really significant about it is what the court did about the question of severability when a part of a statute is found unconstitutional. So the TCPA was established to help combat robocalls. You can't get robocalls unless you've given prior consent. In 2015, the law was amended to also extend that to smartphones. But there was this exception for robocalls that were made on behalf of the government to collect a debt. So if they're calling about student loans or mortgage debts. The plaintiffs here were political and nonprofit organizations that wanted to make political robocalls. And they wanted to get the TCPA out of the way. So their way of doing it was to bring a First Amendment challenge to this government exception, saying that that speech is being unconstitutionally favored over our political speech. But their goal wasn't to have that exception severed, but instead to blow up the entire TCPA. And the court here had issued a number of fractured opinions. 6 members of the court said First Amendment is violated here. But I think the more important thing to focus on is the fact that 7 members of the court, in a number of different opinions, held that government debt exception is just severable from the statute, and the rest of the TCPA stands. Everyone but Justice Thomas and Justice Gorsuch would have come to that result. And the reason that's significant is because to preview this upcoming term where the Affordable Care Act is on the docket, the question is whether the individual mandate, if it's unconstitutional now because the tax basis that the court had previously given for finding that the ACA to be permissible is now 0. Do you just get rid of that mandate, or does it blow up the entire Affordable Care Act? And what this case shows is that regardless of being viewed as more conservative justice, more liberal justice, there's broad consensus around the severability principle. And so a number of commentators are saying with respect to the Affordable Care Act, any scale back from the court is likely to be limited and likely to be severed from the rest of the statute. Steve?
So I think given the time that's left, although I really wanted to talk about the second Aaron Burr case, I think we're going to skip to just a few comments about the upcoming term before we conclude today. So there's a number of really fascinating cases that are coming up. They involve jurisdictional issues, particularly Ford Motor Company versus Bandemer, which is going to determine whether the issues that arise out of or relate to the due process clause are met when none of the defendant's forum contacts cause the plaintiff's claims. There are some interesting cases on intellectual property. There are some very interesting cases on the 8th Amendment and on how the Alien Tort Statute is going to apply to domestic corporations. But frankly, none of these come anywhere near in terms of importance to the issue that we all think is probably going to end up before the court, and that is the election. And let me just, in 30 seconds, remind everyone of Bush versus Gore. There were essentially 2 issues in Bush versus Gore back in 2000. One was whether the different methods of counting votes at the time complied with due process and equal protection. And the court found, I think unanimously, or at least 7-2, that they did not. But there was a second part of the opinion. And the second part of the opinion basically said, time's up. We're not going to send this back to the Florida Supreme Court and to determine a method that does pass constitutional muster. I think that many people view particularly that second part of the opinion as kind of the low watermark of the most recent court, because there's certainly no constitutional rationale. And if you read it, there's almost no rationale at all. And it was viewed by many as being politically driven and therefore damaging to the court. We're now at a point in our country that because of the dysfunction and gridlock between the legislature and executive branches, we're having all these issues pushed to the court itself. And the nominations now for justices are openly political. There's no doubt about why people are being nominated. They're being nominated in large part for their political views as well as their legal acumen. So I think there is a real risk that the court is viewed as just another sort of political branch of government. And the risk is, I think, that it could suffer irreparable damage. I think it is, frankly, probably a disaster if this goes to the court. I think the justices, my guess is the justices would want nothing to do with with voting issues and would rather not deal with this, but they're probably going to have to do it. And how they handle it, I think, will may well determine who's the president, and it may also well determine how the Supreme Court is viewed by the public and by voters going forward. So I think it seems like it's almost inevitable at this point, given the fact that the sides are lawyering up and the statements made by President Trump in particular. So we'll see what happens, and then all eyes, I think, will be on Judge Barrett if she's confirmed, and how she'll shape the court, particularly in this really turbulent time. So that's our presentation for today. Thank you for joining us. We appreciate it. We ran a couple of minutes over. Thank you for sticking with us. Hold on to your seats. November and December are going to be very interesting months at the U.S. Supreme Court. Thank you.